29(1)(f), I think 95% of the prohibitions are in the area of 29(f), with the fraudulent documents, passports and the like. In terms of grounds of appeal, 95%, I would say, of that is usually a person saying they went to an agent. Their fellow countryman or woman told them to go to this particular person, they can get them a visa. Others, agents that are outside DHA or VFS offices. So I came to Home Affairs, there was a guy who approached me, said to pay 5,000, and next minute he came out with an ID or whatever. And it's usually paid in cash and it's not traceable. Sometimes, well, we met at a Wimpy, handed cash, came back 2 weeks later, there's a visa on my passport. And then a lot of South African passports in fake names. So you have somebody who gets a South African passport with not their real name. They marry a South African. They register the children with birth certificates in that fake name and eventually decide to come clean. Very difficult cases, but there are many of those types of cases. So, but certain non-visa waived countries don't have that. So assuming I had 90 days, I left, came back, thought I'd get another 90, and then when I left I was told, no, your 90 days expired when you first came through the port of entry. Flight cancellation, very common one. So flight cancelled, the airline drives you to a hotel, you fly the next morning, it's 1 day overstay. Car breakdown on the way to border, very common one. Became someone with a citizen with a foreign passport. They can't renew the South African passport, or it's not going to come in time. They leave with a foreign one. Told, oh, you've overstayed over 1,000 days, and you know that one happens. Waivers. What is important that should clear the waiver? The overstay. Verifiable evidence, medical reports that can be verified, the flight delays or arrival at ports of entry just after midnight. What is the evidence that you give? Sometimes this person says, yeah, I went to Quick Fit, I had to wait till the morning. Look, I went to Quick Fit near Kopfontein border, minors. It's a strange one, this one, minors. If I was king for a day, I would have said, well, you know, what do they know? They're in the, you know, they're under the care of a parent, so, you know, giving them an overstay or ban, it's thing. We've had, you know, a baby born, 3 months, gets the Italian passports, leaves, and then gets an overstay ban. Doesn't make sense. Then, of course, family life, married to a South African children, you know, the mum goes back home for a funeral, you get a ban. I mean, that should be an upliftment, because you know that in terms of case law, constitutionally, right to family life is sacred.
Good afternoon. Maybe let me first say protocol observed, so that I become correct in terms of acknowledging rights which are present in this room. But a special appreciation to the table on the far right, because without them we will not be here. I'm a practical person. If I were to steal a comment made by one of the attendees of this workshop, I'm going to deal with practical matters so that when you go back to your offices, you know exactly what to do with matters related to the Department of Employment and Labor. And luckily, you can see colleagues from Labor and of course from DTIC. These are easily accessible people. It should not be an issue for you to pick up a phone and call like, you know, Floyd or Griffin. We are very accessible. Let me first start by coughing up something which actually did not sit well with me. Sometime, I think it's last year, late last year or early this year, there was a meeting that was called by Home Affairs by Mr. Pindi Wembele. He was to provide feedback in terms of the Trusted Employer Scheme. And many of you were in attendance of that meeting. Knowingly or unknowingly, you said something or you did something which did not sit well with me. When he actually gave feedback in terms of that program, he said to you, the minister has waived Regulation 18, which is a letter from the Department of Employment and Labor, and you all applauded. That hurt me. That really hurt me. And I was confused to say, I thought we were partners. But it seems as if we are not partners. So I want this day, this opportunity, to actually bring us back closer together, because I know you thought this was going to make life easy for you, but we know what is happening. All right, colleagues, let's first start with statistics. We used to handle quite a number of applications in our offices. That was the same with you in your offices. In 2023, we received 94 applications, and we recommended positively 59 of those 94 applications. They were both general work visas and corporate visas. The number of migrants which were applied for, they amounted to 990. We recommended negatively 35, and we recommended positively 1,167. That simply tells you that we are not actually the stumbling block to labor migration. The numbers are telling. In 2024, the number declined. And obviously, we all know why the numbers declined. We handled 46 applications. We recommended 32 positively. The number of migrants involved, 922. Those recommended negatively, 14 still. Those who were recommended positively, 3,407. And then obviously in 2025, I remember 2024 October, that's when we received the letter, the famous letter, where work had to decline. Department of Employment and Labor no longer participating in the general work visa, and now we were left with a corporate. That's why the numbers declined. In 2025, to date, 22 applications received, 19 recommended positively, almost 100% they recommended positively. Migrants involved, 1,343 recommended negatively, only 3. 722 were recommended positively. So you cannot say the Department of Employment and Labor is not supporting labor migration in South Africa. The numbers are telling again. And the skills which were required, they range from IT professionals who are seeking 100 plus, your chief technical officers, your ship-to-ship transfer superintendent within the maritime space. That is one sector that you need to focus on. That sector is becoming active and busy, and they lack the knowledge that you have. We lost an investment in that sector because the employer did not make use of your services. When they approached us, they thought, no, labor is demanding a lot in terms of advertising opportunities, and they decided not to pursue us. They went to Namibia. So there is work in that space. And then, of course, other skills required were from the diamond industry, your helium mpox operator, etc. Let me not bother you with that. You get the presentation. But the sectors that we dealt with, the sectors I did not include here, but mostly it will be manufacturing in terms of the scarce skill, agriculture, obviously, is the bulk of it, and other sectors as well. But the countries that are actually importing or bringing foreign labor, China is number 1, India is second, and then you have your United Kingdom, Israel, Belgium, Pakistan, Zimbabwe, Lesotho, Mozambique, Namibia within the agricultural space. And then of course the totals are there. But I must mention Agriculture is keeping us busy. I wouldn't say most employers are actually making use of your services. It's actually 50-50, if I were to tell. But where your involvement is, those applications are finalized quicker because obviously employers are compliant in terms of our labor laws and other things that are involved in processing such applications. Now, in terms of what you ought to advise your employers or your clients in terms of our processes, there are two hurdles that employers need to cross. The first one is compliance to labor laws. The second one is diligence search. With compliance, in fact, we are actually talking about all 5 competencies of inspections, from Basic Conditions of Employment Act, Occupational Health and Safety Act, Unemployment Insurance Act, Compensation, shortly QUEDA, and lastly, Employment Equity Act. Compliance is very key. My colleague spoke about the National Labour Migration Policy. In the old regime, or in the current regime, as far as inspection is concerned, a labor inspector has no jurisdiction to enforce Immigration Act because of the Basic Conditions of Employment Act definition of a labor inspector. I remember we are left with 2 visa types where we are playing a role, which is a corporate visa and also a business visa. And luckily, up until now, no one has spoken about our role in the business visa. I was expecting people will bombard us with comments in that space, because you know, if a company needs to renew a business visa, you need that letter from Department of Employment and Labor to confirm the 60-40 ratio. And we've been receiving, or we are flooded actually by yourselves, by DTIC, with the requirement of that letter. Maybe let me just explain. Part of it is what I just explained, to say a labor inspector cannot enforce an immigration law. So we had a robust discussions internally in terms of that. Other ideas were, maybe let's subject all these applications under a DJ review. But a DJ review, it's more punitive if an employer does not comply, and it carries a hefty fine. So maybe it was not a better option to consider. But we engaged extensively. We have engaged, and we have come out with a decision to proceed with the 60-40. Bear with us, we are going to move in that space. I know it's long overdue. But compliance is very key. If you can understand the issues of compliance as far as these labor competencies in terms of statutes are concerned, it will make your life easy. In terms of the National Labour Migration Policy, we will be focusing on enforcement, because now inspectors will be empowered to enforce. And then in terms of diligence search, when we talk about an advert, or when the Immigration Act talks about diligence search, your understanding of a diligence search is different from our understanding of a diligence search. For an employer to put out an advert and collect information and submit to the Department of Employment and Labor, that is not enough for us, because we have no control in that space. An employer normally would say, we have advertised, no one responded to the advert, and then expects the Department of Employment and Labor to issue out that letter. No, it doesn't work like that. The burden of proof is with the employer, it's also with us as well. That's why we also do our own referral. But if that application comes to us, and when you look at the detail, you can see that the employer really did work in terms of trying to find locals. It passes through the adjudication committee, and in more often than not, it is supported. But if the file does not convince even us as the secretariat of that committee, no, it's not going to pass. Now, of course, the employer is required to advertise. over and above advertising, the employer, this is just intel for you, the employer must approach your private employment agencies so that there's proof that the employer really tried to find local skill, not only by an advert, and then it will make life easy as far as this is concerned. Lastly, the process. Let me just paint a picture what happens when you submit an application to the Department of Employment and Labor. You will be dealing with a local office in terms of doing diligence search. You will indicate that you need to recruit for a particular skill, and the local office obviously will now look into our own database. But at the same time, while that is happening, our inspections will be triggered to come to the site of the employer to check compliance. We always advise that when you approach us, make sure that the advert is already out, so that we cut out, of all the departments involved in this process, we are the only department, DTIC, we are the only department that actually has a shortest turnaround time, which is 30 working days. You can hold us to that one. If you work with us, 30 working days. And 30 working days is the maximum duration. It can be shorter than that if you communicate with us. But you go to the local office for RS&R, which is recruitment, selection, and referral. Once those two processes are completed, which is diligence search and also inspections, it moves now to the next phase, which is our provincial office, where the whole file will have to be submitted to the provincial office. And there are politics now in terms of can you submit those applications to our offices or not, which is the same with maybe TTI. With us, it is not an official position to say, hey, okay, my supervisor's here. It's not an official position for us to say you cannot. But there are reasons for that. So our advice is you can advise your employer at the back office. But in terms of submitting paperwork, let it be the employer, because formally so we do not correspond with you in terms of communicating the feedback of the adjudication committee. It has to be to the employer, so that even when there is a recourse sought, we actually engage the applicant employer, not yourselves as intermediaries. But we are open in terms of advice. There are sometimes cases where we allow you to submit, especially at head office, because when it gets to head office, that's when we begin to engage. But at the provincial office and the local office, we are dealing with the employer there. And then when it gets to head office, now there is a checklist that we actually issue out so that you are able to assist your clients. If all those documents on the checklist are on that file, it comes to us for adjudication. When it comes to us for adjudication, that's when we begin to communicate with the employer. If you are involved with yourself, because you must always be informed to make that process quicker. We are part of the secretariat where if there is information missing, we then engage. Once the file is complete, we present that application to the committee. Now we represent the employer in that committee. All questions that the committee members will be asking, we are required to be answering those questions. That's why we always engage, and that's why we promote access. Please feel free to communicate with us. Once we present the application to the committee, and then they will give their verdict. If our presentation was top-notch, if our presentation was not A-OK, it might delay. But there are instances where we engage our partners, TTIC and Home Affairs, especially if it's an employer who wants to invest, to say, we are not comfortable with the file. Can we have this employer to come and represent himself in the interdepartmental meeting? That's when we will invite the employer, and then they will make their representation, and eventually we'll come to a determination. That is the process as far as practicals are concerned. I hope I've allayed your fears. I've attended to issues that you had questions on, but we are available for the next 10 minutes, colleagues. So we have other commitments outside. If you are unable to answer all your questions, like I said, I extended an invitation. Our contact details are with the Secretariat, Ms. Gerda, Ms. Belinda, and okay. So feel free to communicate. There is one person who's in the room. We've been speaking via emails. I've extended an invitation to her to come to us. She did not come. Please, we are accessible. I therefore rest my tongue.
Including Mr. Laki Tswari, in the manner in which he articulated issues with regards to your department and the contribution and the intervention thereof. So thank you very much. We're going to open the floor. As Mr. Tswari has indicated that they only have 10 minutes. So we're going to open the floor to take up a few questions, and also online as well. We're going to take up some few questions. So can we have the mic, please? The gentleman there. Thank you.
Thank you, Mabuto Nicholas Mapena, once again, African Diaspora Forum. It's interesting, the issue of quota system at the workplace. For instance, domestic and agriculture. Agriculture is split into two. You have permanent workers, and the challenge that we face is with the seasonal workers who will come, say, for harvesting. So the issue of enforcing this, we found it to be difficult, and the proposal was why not consider reverting to a seasonal work permit, because people that are coming to work on the farms will be working for a specific period of time. And of course, you then have a lot of exploitation with the domestic workers, because unlike a hotel of this nature, where the labor department inspectors can come, check the number of employees, their nationalities, but given the industry, the domestic work, that it's actually homes, and it makes it difficult for inspectors to get there. We have seen a lot of exploitation in that industry, in that some workers then are kept there as what is called to stay in. They cannot go outside. They will then be forced to work long hours. So we have been making this proposal to say, while we understand that unemployment in South Africa is high, but given this sector, domestic workers, why not reconsider a possible special arrangement for the domestic workers? Thanks a lot.
Thank you so much. Your presentation was informative. I just wanted to understand, could you explain to me where you fit in the process flow? I'm kind of a practical person as well. So if you're applying for a corporate permit, do we go to DTI first? Do we go to Labour first? What do we do, and in what order? Thank you.
I'll take another set of questions, please. Thank you.
Good day, thank you very much. I'm not too sure what relevance my question will have. I'm Abed Said. You know what I don't understand is, if you look at the way online is going, you get a major company like, can you hear me?
Yes, we can.
You get a major company like Walmart, who takes over Macro, right? And you look at Game all over the place. Game has closed on many shops. What does Department of Labor do in terms of protecting our employees? I just want to know this, because it always comes to my mind how things are being done. Thank you very much.
Thank you. I'll take one set of questions. Thank you.
Hello, it's Clark Gradon here again. The microphone seems a bit echoey, but never mind. And one thing I was thinking about was with the corporate permit with regard to the advertising. Is it still required that you need the 6x6 in a newspaper again, or do you do it through private recruitment agencies? I always think it's a bit old using paper adverts. The number of distribution of papers to individuals is very low, so it doesn't get a very high amount of applications seen. The other thing is, I was very concerned when one of my applicants came to me the other day. He was doing something totally different. He came to me with a corporate work permit as a worker on a farm, and he's actually a carpenter. So I was very concerned that the Border Management Authority knows how to give out these authorizations to work. That's my main two things.
Thank you. I'll take those set of questions for now. Then we'll ask for answers when it comes to those questions. Can we also ask the representatives of the Department of Employment and Labour to also just bear with us for a few minutes? I know that you are compressed with regards to time, but I think it is important that perhaps maybe we deal with these issues. Thank you. Can I have the microphone, please? Thank you.
Thanks. Can you hear me? Okay. For corporate visa, where you start at Labour or Department of Trade and Industry, you start with the Department of Employment and Labour, because at Home Affairs, when you go and apply, you must ensure that you have the letter from the Department of Labour. There is no way you will go to Home Affairs without letter. I think those processes will run parallel. You'll start with Home Affairs depending on the sector that you are applying. Because agriculture, they don't go to DTI. They apply directly to Department of Employment and Labour to Home Affairs. But for the ones that start with the DTI, then they need to have the letter from DTI as well as Labour before they go to Home Affairs. So it depends. On the advert, you said the size of the advert.
The size of the advert used to be stated.
So
I'm not sure if it still is.
No, it's no longer there. It was on the immigration, yes. So they removed it. But the advert, what we always emphasize is that the advert must be clear. Because some of the employers...
National newspapers or?
For agriculture, the advert must be on a national newspaper for seasonal farm workers. But for other positions, it must be on the national newspaper or online. But it can, or online, but not on your company's website. On the online where it will be accessible to everyone. Yes. And
the recruitment agency will be able to specify where the address is. In other words, if it's on the internet and the recruitment agency specifically states that, I would have thought that would be sufficient. You say as long as it's clear.
Oh, okay. And also the number of the timeline for the advert, we are specific on that one. At least in 30 days, your advert must be open. You cannot advertise today, next week you are applying. You must give South Africans enough time to be able to respond on the advert. What else? The carpenter with corporate visa. Carpenter. One carpenter with the corporate visa or with the authorization from the Department of Home Affairs. What I know, maybe Home Affairs they will assist on that one. With the process from Labour, when you apply for corporate, it will be a group, and that corporate will be submitted to Home Affairs. Home Affairs is the one that will issue the authorization certificate for the individuals who are applying.
It's just that, as far as I'm concerned, border management authorization, border management people must get their
ducks in a row. If people can't get the wrong document.
Maybe Home Affairs can assist on that one. But the Employment Services Act, it says you cannot have the authorization of ShopRite and go and work with that authorization at Pick and Pay. Maybe my colleague will assist you in the other questions.
My interest is actually on farm workers. Someone spoke about the protection of employees within that sector. I remember the issue of labor migration is very an emotive issue, which is something that I did not want to touch on. Because when you are dealing with employers, they are pro-migrants. But when you are dealing with citizens, they are anti-migrant. There are advocacy groups involved as well. But in terms of protection of employees in farms, the labor, together with Home Affairs Inspectorate and the police, we from time to time conduct blitz inspection to look into those issues. Even when you apply for a corporate visa as a farmer, that's why we first subject you to inspection to check the issues of accommodation and related issues, so that there are no issues which will come out after we have approved or recommended positively in that space. But of course, we cannot be everywhere as far as farms are concerned. There are so many farms in South Africa. Of course, in other areas, you'll find that there are ill treatment of these farmers. Hence, people will talk about cheap labor. But lastly, consider also that you have farmers which are in the borders of South Africa and neighboring countries, where we are unable to provide locals to work in those farms. So there will always be issues as far as employment of foreigners is concerned within agriculture. Thank you.
Oh, sorry, just to add, on the quota system for agriculture, my colleague talks about the seasonal farm workers. On the issue of quota system, it is not going to be one size fits all. It's going to differ. You might find that quota system is not going to work for agriculture. Maybe there will be MOUs that will be signed between the two countries. It's not going to be a quota system for that, but it will depend once the framework is developed on that one. Thank you.
I think there was just one more question.
Yes, sorry, apologies, me again. I wanted to understand the process for a renewal of a business visa. You said that the Department of Labour, Department of Labour has a role to play in that. Can you just map that process for me? What does it mean? What do we need to supply to you? And is it a current process or a future plan?
Oh, I thought you were asking a question. Okay, the process for the business visa. Remember, the requirement, it says the Department of Labour need to confirm if the company, the staff establishment is 60-40, 60% are South African and 40% are foreign nationals. So the Department of Employment and Labour need to confirm that. And that 60-40, South Africans need to participate from all the levels, from management to lower positions. So the information that will be required from the employer, it will be that confirmation that South Africans are participating from the management until from the lower level. You will need that proof from the employer. Remember, the employees, they are registered from our system, the Unemployment Act, they are declared as employees. So our system will be able to draw whatever information that will be provided by the employee. When you press the button, the system will tell us from this company, even the employment equity, if the company is designated, it will tell that the number of South Africans in this company from management are this number, then it will assist us. That's where the letter will be issued to the employer that, okay, the employer, yes, indeed, they confirm with the 60-40. Not only that South Africans, they are only clerks. No, that's not compliant. Even if they are 70%, but if they are not participating on all levels, that's a non-compliant. But there will be forms that will be shared once the process, we are continuing with it. Definitely we are going to continue it, but once they are approved, because they are still going to be approved internally, we will share them on our department website once they are approved.
Contribution in this process, definitely. The turnaround time from their office is 30 days, not necessarily prior to that, but that is something else that we should, I think, work on. Actually, in the 2014 regulations, it is mentioned in terms of renewing a business visa that you should provide that certification. So it's now a good introduction that there will be now, a formal process in place. I think it will also be beneficial to business visa holders to be able to prove that they have recruited those, and hopefully that will also positively have an effect on Department of Trade and Industry recommendations, also the Department of Home Affairs, quicker turnaround of approvals and outcomes. In terms of my experience is in terms of the corporate visa process in the Western Cape. Our process is actually, and Mr. Lucky indicated, it starts at the local office. Actually, in the Western Cape, it starts at the provincial office, and they issue the acknowledgement. And then they will form the applicants, because we're not allowed to be part of the process, very understandable. And then the employer will be informed that this will now be forwarded to the local office. So our experience is in terms of advertisement. Also, it's very important that the local newspapers need to be involved in the advertisement. The issue always will be how to prove the skills and experience that the person will need, the diligence search in the area in terms of availability, and that sometimes become a frustrating issue, because in terms of the advertisement, either online, national newspaper, or even local newspapers, in the majority of cases, then the prospective or the corporate visa applicant is then presented with a list of persons that are registered at the local office as unemployed, and that our experience, we find it then difficult to prove to the satisfaction of the head office eventually, and even the provincial office, in terms of recommending that they are not really local label available.
Thank you.
Okay, thank you. The process for corporate visa, for recruitment, it starts at the labor center, like my colleague presented. You start at the labor center. We start by recruiting first before we can apply for a permit. Permit is the last option. We test the local labor market first with the labor center. Once the labor center, they were unable to find, or they were able to find South Africans, they will communicate with the provincial office with the information. But when the employer submit the application, the labor center, they don't accept any application. It must be the provincial office that will take the application, unless in the situation whereby the provincial office is far from the employer, like in the case of Springbok and Kimberley. The labor center, Springbok, we cannot tell the employer from Springbok to go to Kimberley and submit the application. That employer, because of distance, can submit the application at the labor center instead of provincial office. But Gauteng, no, you cannot. KZN, you can submit at the labor center, because employer from Newcastle cannot come to Devon and submit. It depends, but Gauteng, no, because we are all around. They can submit there. I'm not sure if I covered.
there's just a few follow-up. Oh, yes, please.
I'm so glad everybody's becoming more practical. There's actually a government department that is also practical. So I like the numbers that I saw because everybody can agree on those numbers, as we heard. My question is pretty much the same as a gentleman asking about the Walmart and the game. It is troubling for me that we don't have statistics about people going out of the country, because some of those people are big business people. They leave employees behind, and what happens to those employees? So I would urge that when you start running the numbers, it is quite upsetting for me that Stats SA and for example you and all of the other departments have got different types of numbers, and we don't have a universal number. So I think on that there needs to be definite collaboration, and it needs to happen fast. If you want to have people's attention, you need to have evidence, and evidence lies in numbers. Thank you.
Thank you.
Sorry, Program Director, I wanted to add the skill of locals who are not fitting the bill, hence now the need for a corporate visa. We said for us to be convinced that the employer has conducted a diligent search, the employer must, because the burden of proof sits with the employer and with us, but with the employer must just make sure. Hence your advice as a practitioner to say, if the employer is looking for, agriculture is not a scarce skill, but there are always issues with employers who actually prefer foreigners over locals for reasons known to us and to employers. We are aware of that. What we want is give us information to show that you actually tried to recruit locals. Don't just say no skill. It can't be no skill because it's not a scarce skill, but give us reasons. One of the reasons that we normally get is that they normally employ locals. Over a period of 2 weeks or a month, the locals are no longer employed because they have absconded. We take such issues into consideration. So give us proper feedback in terms of recruitment. Feedback is very important after placement, because you would have maybe requested 200 and the department referred 400. What happened with the 400? So you cannot come back to us and say no one was employed or 10 were employed, and you don't give us feedback of the remainder. So we need that feedback as well. Thank you.
Just one more question. I want to understand, Department of Labour is here, Department of Trade and Industry is here, thank you very much. Department of Home Affairs missing. And I feel the question needs to be about how do you, as three organizations, work together? If the Department of Home Affairs is talking about digitization and everything is going to be done from the palm of their hand, smartphone, AI-generated visas, then how do you expect the submission to be done at the Department of Labour? How do you, with forms, with a manual process, how do we then submit to the Department of Trade and Industry on a separate platform with their processes and their turnaround times and their requirements? And how does the Department of Home Affairs do everything from the palm of their hands or from home in their home? As far as I'm concerned, Home Affairs represents a lot of stress and trauma and chaos in most South Africans' lives. It has a reputation, and I don't want that chaos in my house. So the concept of Home Affairs in my home is quite a scary one. My question is, how does Department of Labour, how does Department of Trade and Industry, and how does Department of Home Affairs start singing from the same song sheet so we can give our clients proper guidance?
Okay, if I can have a bite on it is, okay, let us be clear. The mandates are different. The Department of Employment and Labour does not issue out permits. And the space is actually changing. It's important for us to invest our time in reading the new legislations. Read the National Labour Migration Policy, read the white paper on immigration and citizenship. Because where we are heading is the department will only protect the labour market, South African labour market, whereas Home Affairs will issue out permits. So we don't want to be in the space of permits where we are supposed to be protecting the labour market. So our framework is actually focused on that. As far as the issue of digitization, you know, government, SARS is the only government entity which is actually on the forefront as far as digitization is concerned. Our colleagues from DTIC have spoken about their system, which is digital. As far as alignments are concerned, I'm not sure when that will be, because in our case, we also tried to procure a new system that will make your life easy. But unfortunately, it is a process. These are different systems because we've procured from another service provider which is unknown to Home Affairs, unknown to DTIC. DTIC is internal, but the sweet and short of it is I don't foresee that happening in the short or medium term. But as far as labor is concerned, we don't want to be in that space of permitting because that is not our mandate. Our mandate is to provide labor migration framework, and then Home Affairs will issue out permits. Hopefully there won't be paperwork that is in the process of us providing the framework and then Home Affairs permitting since they are moving digital. Thank you.
Thank you very much. Thank you very much from Mr. Laiki Tori and Ms. Sindiswa Changuion from the Department of Employment and Labour. Thank you very much. Can you just give them a round of applause, please? My fellow ladies and gentlemen, and especially the delegates that had said that Home Affairs is missing in action, the Department of Home Affairs is here. Now, at the heart of the issues of immigration is the Department of Home Affairs. Today, we are joined by another valued guest from the Department of Home Affairs, the Director of Corporate Affairs, Mr. Pindile Mbele. He will be unpacking two pivotal initiatives that are shaping the future of our tourism and labor sectors: the Trusted Employer Scheme and the Trusted Tour Operator Scheme. These frameworks are designed not just as regulatory tools, but as strategic models aimed at increasing operational efficiency, reducing administrative burdens, and accelerating pathways for sustainable economic growth. With deep insights into how these schemes function as enablers of trust between the private sector and government, our speaker will explore how they promote responsible business practices, streamlining workforce mobility, and enhancing the overall tourism ecosystem. By fostering transparency and accountability, these schemes contribute directly to building a more resilient and competitive economy, especially in regions where tourism plays a vital role. Please join us in welcoming online Mr. Pindile Mbele, who will guide us through how these schemes are not only transforming policy implementation, but also unlocking long-term economic potential. Mr. Pindile, Mr. Mbele. Mr. Mbele, are you hearing us?
Yeah, good afternoon. Can you hear me?
Thank you very much, Mr. Mbele. Welcome, welcome.
Yes, thank you very much. Program Director, and thank you very much for the invitation. Good afternoon to you, the government colleagues there, and the members of Fipsa, including the leadership and the executive of Fipsa. I'd just like to render an apology first. Actually, at the Devon ICC, the investment conference of KwaZulu-Natal, I just had a session together with the Department of Tourism, so I could not join you earlier. But also because I had to come in for Mr. Mandla Mativisa, who is the current acting Deputy Director General of the Immigration Services at Home Affairs. He could not come, so he asked that I render an apology for him. So without further ado, you spoke about the visa schemes that Home Affairs has initiated as part of our digital transformation roadmap. When I joined the meeting a few minutes earlier, I heard one of your delegates saying that she does not want to bring Home Affairs chaos to our house. I had to really smile at that and ask myself, when has ever technology brought any chaos to any person's house? In fact, the technology by its very nature is supposed to bring efficiency and reduce the time. And whatever paperwork that she was referring to when she was talking about the processes between us and the Department of Labor. So we as the Department of Home Affairs, you would know, in this administration, we have embarked on what we call the digital transformation roadmap, where we are looking at the activities and processes within the department that can be digitalized. We're using the available technology to assist us as the department as well as our clients in rendering a better service. One of those is an intervention and support that we are giving to the Department of Tourism. The Department of Tourism has a target of bringing in international arrivals to South Africa of 15 million tourists by 2030. And as part of our contribution and support to the Department of Tourism, we initiated a visa scheme that is called the Trusted Tour Operator Scheme, known also for short as TTOS or TTOS. So the TTOS is a scheme where we have focused on the two key markets, which is China and India. And the reason for that being that in 2024 and 2023, the biggest number of travelers globally were from China and India. But unfortunately, out of those millions of tourists that were traveling to different destinations, South Africa had a very small share of that population. And coming out of the research that the Department of Tourism has done, together with the Tourism Business Council and SA Tourism, were a number of issues that indicated what could be the challenges for tourists coming to South Africa. There were many other, some of which are the level of crime, some of which are the fact that South Africa is a long-haul destination. We are actually at the bottom of the planet, and to actually travel to South Africa is much more expensive because of the distance. But then also, travelers who want to go on holiday would not want to be on an airplane for more than 6 to 8 hours. But then in addition to that, one of the issues that was raised was the difficulty in obtaining visas to come to South Africa. in particular for the Chinese market. As you would know that our Immigration Act and immigration regulations prescribe that when you submit documents to us, you need to submit documents in the language of South Africa, any of the South African languages. Now, for a Chinese traveler, that means that they would have to translate their bank statement, their birth certificate if they are traveling with children, or any other document that they have into one of the languages. Primarily, it would be English, and that by itself, we have an additional cost to what they would normally pay for their flight bookings as well as their visas. So now what we then did is that we went out to the market, we issued an invitation for tour companies to submit expressions of interest to register on the TTOS as what we call trusted tour operators. Now in this scheme, when a tour operator has applied and has been admitted, what then happens is that instead of the applicants submitting applications by themselves, the tour operators would submit the applications on behalf of the tourist, and this will come with itself the reduced requirements. For instance, in the TTOS, we do not require the submission of translated bank statements. So a tour operator in China would submit an undertaking that confirms that this applicant, when they came to book a holiday through me, I looked at their documents and I can confirm that they have sufficient financial means to take care of themselves in South Africa or to even pay for their accommodation or whatever needs that they would have. And what we also did is that we also gave a concession to say that those tourists who apply through the trusted tour operators, we will have their visa fees waived. So you would know that when you apply for a visa to come to South Africa in China, and you go to our South African embassy or the mission, you will pay a visa fee, but on the TTOS, you do not pay a fee. And the applications are submitted as group applications. So on the tour operator, trusted tour operator scheme, we only accept applications to be submitted by the tour operator from 2 and above. So we do not take single applications. On the scheme, there are no individuals who make applications by themselves. So the tour operators are the only ones that have access to the system. They have login details that we have given to them, plus a memorandum of agreement that they have signed with the department stating out the terms and conditions of belonging to this. And I can confirm or maybe announce in the meeting that by last week we had already welcomed around 50,000 tourists just on this platform alone from India and China combined, which is quite a significant number if you consider that this scheme only started in February this year. So that is the scheme that we are currently using as the department. And if you look at those numbers, these are just the numbers that are on the scheme. You still have tourists that go straight to the mission to submit their applications. You have others that are submitting their tourist visa applications on the e-visa platform. So if you take those numbers combined, the number will actually be higher than that. So as I've said, this is the contribution that we are giving in supporting the tourism sector recovery plan of the Department of Tourism. And we also believe that this will be further boosted by the introduction of the ETA, the Electronic Travel Authorization, which is expected to increase our international arrivals to over 1 million, and with the possibility of creating 80,000 to 100,000 jobs in the tourism sector. And also in preparation of 2026, you will know that the Meetings Africa and the Travel Indaba have signed an agreement to be hosted in KZN for the next 5 years. So we will be facilitating the travelers through this program. Just to give you the latest stats, the Department of Tourism has reported that in July 2025, we welcomed 880,000 international visitors, which is 26% increase compared to the same month last year. So that is the intervention that we are doing on tourism. We also have another. They had to submit applications by dropping them off at Home Affairs and so forth. Some of the applications reached us, some of them could not reach us because of the size of the application and the applications not being able to go through the email. And now, as part of the digital transformation, the applications and the expressions of interest are going to be submitted online. So there won't be a reason for any application that has been lost. And when we say online, we are not talking about email. We are talking about completing the form online, uploading the documents, and receiving an automated acknowledgement of receipt. When the applications are being adjudicated, and they will be adjudicated using an online platform, and the applicants who are successful and those who are not successful, the employers, would receive their outcomes via the same link that they've used to apply. So while maybe there may be some skepticism with regards to the digital transformation, we as officials of the department are already seeing the benefits, because we have seen a change in the manner in which we are performing our work. So we are quite excited that this time around, the trusted employers will be able to submit applications online. And the other change, as I've mentioned, is that we have also added what we call companies that are abroad who want to have their offices headquartered in South Africa. We are finding a lot of requests from companies that want to move their headquarters to South Africa for many reasons. If you look in other continents out of South Africa, there's some instability, there's war in some continents, and there's anti-immigrant sentiment in other countries as well. And at the current moment, the focus seems to be that most countries would like to settle down south, which is in this case South Africa. So we'll also be accommodating companies that want to move their head offices to South Africa. Lastly, to add on a point that when I came in, my colleague Lakitswa was speaking about, you would know that for general work visas, the Minister of Home Affairs has given a blanket waiver that we no longer need the certificate of the Department of Labor on general work visas. So in our processing of visas and permits, the Department of Labor certificate is now only required on corporate visas, but it is no longer there in general work visas. And this is due to the fact that we are now using the points-based system for the PBS that was introduced by the Minister in October last year. Chairperson, let me end here, and I think maybe I'll be able to address others as and when I get questions. Thank you very much.
Thank you, Mr. Mbele. We had just missed some few minutes of your presentation. I think you were not aware that you went offline, but I think at the crux of the presentation, most of the delegates have received the presentation, and there are just few questions that are going to be imposed from the floor, and also the questions that are going to be taken from online. Can I perhaps ask the chairperson of Fipsa to begin with the question? Can I have the revolving mic, please?
afternoon. Good afternoon.
Can we please assist with regards to the mic? It's not audible.
Good afternoon, Mr. Mbele. Good afternoon.
Good afternoon, Chairperson.
From what you were saying, I've got one question. DHA and Fipsa's relationship, can you address that? And then the issue of the point-based system and the verification process.
Can I take a follow-up question? Mr. Mbele, can you just bear with us? We're going to be taking 4 questions at a time from the floor and also online. And after those 4 questions, we'll implore you to respond, please. Thank you.
Hello, Mr. Mbele, it's Slav Brandon here. One of the things that you were busy talking about, I'm not sure exactly what you intended to say. You were talking about the trusted tourists sector, and then you were trusted tourist operator. Then you said something trusted, and then you disappeared. I'm not sure if you were going to talk about the trusted employer scheme. But if you are you going, is there an intention to reopen it?
Has it gone offline as well?
Recording in progress.
Mr. Mbele, are you online? Can you hear us? Mr. Mbele?
That I cannot hear the person asking the 4th question, so I don't know whether it's my device or was it the mic.
I'm just going to request the delegate that was asking a question to repeat the question, please, for Mr. Mbele.
Mr. Mbele, it was regarding the trusted employer scheme. Are you going to be reopening the scheme, or is it still closed for the moment? That was it.
Did you capture that, Mr. Mbele? Can I ask the following delegate, please, and then...
I'm sorry, Chair.
Yes.
I didn't get that. Yeah.
Okay. Can I perhaps maybe ask you, sir, one more time to ask the question again? My apology, please. We seem to have a network problem, I think. Maybe come to the side, please. Thank you. You are more than welcome.
Sorry, Mr. Mbele. It was just regard to the trusted employer scheme. My understanding is that it's currently closed. Is it the intention of Home Affairs to open it again?
Mr. Mbele, you got that?
I won't have the question, but is he asking about the TTOS being currently closed? Is that what he was asking about?
Yes, that's exactly what he's asking. What is he asking about? The trusted employer.
Yes.
Okay.
Oh, okay.
All right.
All right.
So let me Mr. Mbele, can we just take maybe one more question and then you can be able to answer the 3 questions that were posed on the floor?
Okay.
Thank you. Can I have another follow-up question, please, from the floor?
Anyone from the floor?
There you go.
Hi, Mr. Mbele. Just to follow up on the other question, I think most of us in answering your question about whether the TES will be reopened, would you also just rehash what changes are going to be included in that, in particular around the investment thresholds of the TES? Currently they're sitting around about 200 million. That's a quite high bar for most companies that might be seeking to participate. So that sort of explanation.
Do we have any question online?
No, we've got no online questions, but
Yes.
what we are noticing is this mic is not reflecting on the side where the virtual attendees are. So I'm going to ask, if someone's asking a question, if they can come up there to you, Cindy, and ask the question there.
Please come through the side. Mr. Mbele, can you just bear with us whilst we still sort out our technical issues?
Mr. Mbele is around the TES, and it's follow-up on the other question. Most of us on this side didn't actually hear most of the presentation about the TES. It suggested that there are some changes you were talking about, and I was wondering if you can just rehash those aspects, in particular whether if it's reopening, what changes are coming, and will there be a consideration around, number one, the investment thresholds around the trusted employer scheme. Currently they're quite high. Set up around about 100 million or 200 million rand with 100 employees. That's a different kind of company. We're talking about large companies, and it excludes a lot of SMEs who may want to participate and benefit from the points-based system, because there's a big chunk of points that people aren't able to access as a result of not being able to reach the thresholds of the TES. Thanks.
Thank you. Before I go online and read a question that is posed by Mr. Hassan from Global Diaspora, can I ask Mr. Mbele to respond to the 3 questions that have been posed? I hope you heard all of them, Mr. Mbele.
Yeah, I hope I will recall all the questions, but let me start with this one of the second phase of the TES. Let's start with the threshold. The threshold that we have in the TES is aligned with the threshold of what is in the presidential the annual investment session that we have. So we've aligned this with the requirements from the DTIC. And we are quite deliberate in it that we are attracting, or we are focusing on big corporates and big investors, because as you can imagine, if a company is an SMME, chances of it employing foreigners and South Africans at the same time are quite low. But then also, the annual subscription that is required, and that is currently being discussed internally, is not an amount that an SME would be able to afford, but it's an amount that a medium corporate company would be able to afford. So we have not reduced the threshold in as far as those monies or the revenue is concerned. And also the reason for this is that we are not looking at opening the scheme to all companies, because then it becomes inefficient. If we have to attend to 1,000 companies in a scheme, you will not be able to give them the service that you want them to, that you want to give to them. And so far, with around 107 TES companies that we have in phase 1, we have been able to manage them quite comfortably, even in terms of following them up and checking whether they are keeping to the terms and conditions of the TES. So the simple and short answer to that is that we have not reduced the threshold at all. The other colleague before, the one of the TES, I'm not sure whether he was also speaking about the TES or was he talking about the tourist one. But if he was talking about the TES, I guess the same response will go to him.
Mr. Musiani asked 3 questions. I missed the 2, but I remember the first question that he asked about what is the relationship of the Department of Home Affairs with Fipsa. It's quite a tricky one because the Department of Home Affairs has different stakeholders. If you go to refugee and asylum management, they have stakeholders which are people that operate in the same space or that they do and have a similar interest, sometimes even opposing interests. So I would say that the relationship with Fipsa would be a relationship that we would have with any other entity, organization, individuals, private and otherwise, who are in the immigration space and have a similar interest as the department, or sometimes an opposing interest. We view them as stakeholders in the work that they do. And where there's opportunity for collaboration, sharing best practice, or even getting input on how we can improve our systems, we always appreciate such input. But we do not have a particular posture or position for or against Fipsa or any other stakeholder for that matter as the Department of Home Affairs. So that will be my response to the first question. If you can just remind me of the 2 questions, Program Director.
There are other 2 questions that needed clarity. Let me just get those questions from the floor. Then I'll be able to indicate which ones are those. Can you just, thank you.
Hi, Ms. Mbele. This is Nadia Heinz, and I'm just going to repeat our chair's, Gershon Moshiani's 2 questions. The one is the verification process with regards to spousal visas, specifically with regards to the calling and trying to verify the spousal relationship. What we have noted on the ground was very often one call is being made, and thereafter, if the person didn't answer the application for whether it is a permanent residence application or a spousal relative visa or Section 11(6) is rejected. So that's the one. And the second one is the point-based system. If you can just maybe share a little bit more about that. We do have a question that ties in with the beginning of the Indaba, which you did miss. And that was where the Department of Home Affairs also stipulated in the minister's recorded address that there was a visa backlog. We are aware that the waivers are still in backlog, but we do not want to know is what are the transitional arrangements that have been made for those applicants that have applied for a Department of Labour waiver prior to the implementation of the point-based system, that are currently still awaiting their outcomes, because according to the new point-based system, should they apply for a work permit now, they will be subjected to the point-based system, which is not fair towards them because they have actually applied for their waivers prior to such. Thank you.
All right. Okay, let me start first with the one of the point-based system. I think colleagues by now are all familiar with the point-based system, the scoring of the points and so forth. I'm sure the biggest part of your question is on the transitional arrangements. Usually, if there are any transitional arrangements, those will get published. So the minister would have put the transitional arrangement in whatever documents that you would have published. In as far as I'm aware, there are no transitional arrangements, except for the fact that if you go and you read the regulations that were amended when you go to the points-based system, the regulations say that an application for a general work visa and critical skills work visa must be adjudicated with points using a point-based system, which is a different language from what you would normally see in the other text of the legislation, where we use the MAY. That something may, if you apply for a visa, the Director General may, meaning that it is not definite that if you apply for a visa, you will get it. So you'll find a lot of may. If you are rejected, then you are aggrieved with the decision of the department, you may submit an appeal. The legislation does not say you must, because you might feel that, okay, the rejection is correct, so I don't need to submit an appeal. I agree with the department. So, but when it comes to the point-based system, if you really would say it must. So, adjudicators and officials of the department have not been given any other alternative to say you must adjudicate according to the points-based systems, except or where applicable. So, as you would know, with legislation, once it is published, it becomes effective from the date of application. So, I suppose that these issues then are issues that if they are to be brought to the attention of the minister has appointed an immigration advisory board, and the assumption would be that all stakeholders and all industries would have a voice or a representative on the IAB would be able to flag some of these issues to the minister. With regards to verification takes different shapes. So in an 11-6, you have a couple who are either married. In South Africa, they have a marriage certificate issued by the Department of Home Affairs. That is within our control. It is within our systems. We are able to check and confirm whether this person is married. Then we also what we have, what we refer to as marriage of convenience. So some people might have been married and they have a genuine marriage certificate from the Department of Home Affairs, but it is a marriage of convenience, meaning that they don't stay together, they might not even know each other, or they've never met, and the marriage itself might be fraudulent. So you then need to call, in particular, the South African who has been married to this person, and you take them through an interview where you ask them a number of questions with regards to their relationship. That is where the verification comes from. Most of the South Africans, I can tell you, who are married to foreign nationals, from our experience and the documentation that we get, they would only have a cell phone number on a letter to say, I so-and-so support my partner to apply for a visa. When you call that number, that person does not answer. More often than not, that number belongs to someone else. More often than not, that number belongs even to someone who is not the person that whose details are there. And we are quite aware of that, because if you go to some of our visa application centers, when you walk around the block, you find a lot of South African women that are sitting around what we call rent a bride. Foreign nationals come there, they request one lady to go in with them, take a photo with them, sign the documents, and then that's the last time that they see each other. They give them 2.5 or whatever amount, and then they disappear. So when you call that time to verify, that lady is nowhere to be found. So if a Home Affairs official gives out a visa and they do not have evidence that the relationship was positively verified and confirmed, that Home Affairs official end up being in trouble, end up being suspended or being fired for having issued a visa fraudulently. Now, as a result of that, the colleagues that are working with visas have started to become much more thorough have started to study the regulations much more deeper, so that then they make sure that they do not find themselves having issued visas to people that do not have visas. Now, what happens is that when a verification request has been sent, so we will send a verification request to say, dear Ms. So-and-so at HR, can you please confirm that this contract was issued by you? And then we do not get a response. And remember, we do not pick up our own email addresses anywhere. We take an email address that was supplied in the documents, and the people do not respond. And we then take that email after a certain period, we take it as evidence that we sent a request for verification on this day, on that day, and on the third day, or whatever day, and we did not receive a response. We put it as part of our evidence to say that our verification request was not responded to. We make a call at a particular time, our call is not responded to. We give it some time, we call at another time. Sometimes an adjudicator would have called, they failed to call, and then the application comes through to me. I also do the same thing. I do not get a response. Then we record our logs to say I phoned at 14:15 on the 25th of October. The applicant at this number, all that is captured in our records. And we say we never received any response. As a result, our efforts to verify the relationship failed or remain unanswered. So that is in detail how we do our verification. If we do get a verification where someone says, yes, this person is employed by us, we are able to take that as a document and we upload it, we attach it to the application as evidence that this person knows or is the issuer of the document that we are trying to verify. Thank you.
Thank you, thank you, thank you. Just one more question, Mr. Mbele, and then do you have another question? Just two more questions, Mr. Mbele. Ladies and gentlemen, for the interest of time, we still have 3 guest speakers that have to come through. So just to fast track the process, please, can we just perhaps maybe make sure that we are prompt in terms of questions, please? Thank you.
Mr. Mbele, thank you so much. Candice McGinn, I have a question. I just wanted to understand, what role do Fipsa registered immigration practitioners play in the Department of Home Affairs digitization rollout?
Did you hear that, Mr. Mbele? Can I get a secondary question, please, before we close off?
Thank you, Mr. Mbele. Henry Harper here from Fipsa. The question I have is with regards to section 31(2)(c) of the Act that says any requirement or form can be waived by means of good cause. So the question is would the department look at waiving the points-based system requirement for general work visa? Thank you, sir.
Mr. Mbele, did you hear those questions?
Yes, I've heard the question.
Thank you.
And the first question, I think it's similar to what Mr. Musiani asked. What role is Fipsa playing in the digitization roadmap of the department? The question is that the answer is that the digitization roadmap is currently an internal process where we are looking at our own processes to say what activities can we digitize or we can introduce technology into. In as far as I'm concerned, between those who the question would be in the current process, what role does Fipsa play in the application process that requires digitization? And the question, the answer would have to come from both, or maybe from Fipsa itself, to say in the value chain of the application, this is the role that we play in the application, and this is what we recommend that could be digitized or could be done digitally. So that is something that maybe in your own engagements you might look at, because with every change there's always an opportunity that those that are able to identify an opportunity in it would then be able to put forth a proposal to say we can participate in this particular area. And it will be up to the department to decide on. On the last question that was asked, I answered the one about, what was the last one? No, 31.2c, the waiving of applications, or the waiving of requirements. And as I said earlier when I was answering about the points based, the Immigration Act says that the minister may waive any requirement of form, and the answer is may. And the question would be, if before you submit a waiver, you should ask yourself that the minister decided to revise or amend the regulations to introduce the point-based system. Would a reasonable minister also be willing to waive something that he has introduced as part of making either the work more efficient or not? For an example, I'll just give you an example. When somebody wants to apply for a critical skills visa, and they say, waive the qualification, waive the request for, waive the requirement to belong to a professional body, basically waive anything that defines me as a critically skilled person, but still give me a critical skills visa. I mean, to a reasonable person, the question would be then, if we give you a critical skills visa, having disregarded the factors that define you as a critically skilled person, on what basis would we give you a critical skills visa? Why would we give you a critical skills visa without the requirements of a critical skills visa when you want to waive everything? So the answer to that is that anything that you would want for minister to waive, a minister would consider, but you would know yourself amongst you, there's lawyers, there's something that we call vexatious or vexatious. I always get this word wrong. Litigants, people who just do things for the sake of doing it. So we do find a lot of that, of people who submit waivers for the sake of submitting waivers, but they do not really know what is it that they want. And when there is no good cause, because it says that the minister may waive something for good cause, and the good cause must come from the applicant. It is not the minister that has to think on behalf of the applicant. So if minister does not find a good cause, minister will not accept the waiver, and he will unfortunately have to reject it. But in terms of what the law says, there is nothing that stops anyone from submitting a waiver of a prescribed requirement. Thank you, Program Director.
Thank you, Mr. Mbele. Before we let you go, just one critical question, please. Can you just bear with us? Just one question, and then we can let you go. Thank you.
Mr. Mbele, thank you for that answer. I really appreciate it. Although I just need to, for the sake of clarity, say that, we are not talking about critical skills visa, that's general work visa. And the reason why I posed the question to you is because if you look at the requirements for a points-based system, it's quite high. I mean, in order to get that 100 points, if you look at the set out of it, the minimum requirement, for instance, for a person to earn is 650,000 a year. So that's already a high benchmark for anyone that wanted to apply for general work visa, and we really just need to concentrate on general work visa. So once again, I want to ask you that question, and why I said it in the beginning, if the Department of Home Affairs would consider to waive the requirement for points-based system entirely, because there is a mountain of people out there, a large amount of people out there that would actually qualify for general work visa. Now, I know the benchmark is set high for a specific reason, and I can understand it from your perspective, but I think it might just open up, not open up, but address a lot of problems that we have if we can, if that requirement, obviously for good cause, can be waived, and then in that case, in that instance, have less illegals in the country or foreigners that come in with fake permits and get their fake permits here, So, because employers, from what I've seen, doesn't know the difference between a fake and a real permit, you know. So a lot of the employees come up with them and say, already have a work visa, and they get employed. So I just think, you know, it could be a mechanism to address that problem. Thank you, sir.
Mr. Mbele, just that last question. Can you just respond, sir, before we let you go? Thank you.
Thank you very much, and thanks to the colleague for that question. So just to give you an idea of how the points-based system came about. The point-based system came about as a result of the consideration that a minister would have to waive the certificate of labor. But minister had to do this being responsible, making sure that while removing the Department of Labor certificate, the general work visa would still be available to people who are skilled to a certain level, but may not necessarily be in the critical skills list. I'll just give you an example. If a pilot would not qualify for being on the critical, you know, for a critical skills list, but if they were to apply for a general work visa, they would be able to do so. So removing the Department of Labor certificate meant that minister had to put in another mechanism that will make sure that you do not, for an example, what like Ishwari spoke about earlier, you do not find farm workers and domestic workers applying for general work visas. When there are unemployed South Africans who could do that work, even though employers would say otherwise for their own reasons. But it is also to protect the job market, to support the Department of Labor in their objective of making sure that South Africans are given first preference when job opportunities arise. So the thresholds that you see in the general work visa are quite deliberate. Let me say so, are quite deliberate. There were discussions as to how do we get to that threshold of points. Thank you, Program Director.
Thank you, Mr. Mbele. Thank you for the opportunity to engage with the delegates, and thank you for being amenable to accede to the invitation from Fipsa. We thank you very much, and thank you for taking your time out from your respective responsibilities. Thank you for joining us, sir. Thank you very much.
Thank you very much, Chairperson. Once again, my apologies. I would have really loved to be there in person, you know, to engage much more broader with the colleagues there. But hopefully, there would be another opportunity for us to be able to do so. Please accept my apology once again, and apology to the executives, of Fipsa. Thank you.
Thank you. Hopefully, we've got the former acting Deputy Director Immigration Services of the Department of Home Affairs in person, Mr. Matthews Mudiri. Wow. So he's here in person, ladies and gentlemen, and I think your questions and your concerns with regards to issues, he's here in person. Please indulge him so that he can be able to take you through certain processes that are important and your concerns as well. He'll be presenting. We'll be having one more speaker as well from SAQA that will be coming through, and then we'll have the Fipsa leadership to close off our engagement for the day. Mr. Mudiri, Mr. Matthews, the stage is yours. Thank you. Can you give him a hand of applause now?
Okay, good afternoon. How are you all today? No, well, thanks. Thank you very much for the invitation. My name's Mudiri Matthews, and before I proceed, I just wish to thank the Fipsa executive for the invitation, and it's great to actually meet a lot of you in person. A lot of you I knew in my former life as people on the other side of the phone or other side of an email, wanting outcomes on cases. I also wish to stand on the protocol that's already been extended and to hopefully have a good engagement. If you promise not to cross-examine me. I was assured this will not be a cross-examination. So I've been asked to talk about prohibitions and undesirable cases. To give some insight into it, I'll jump straight to the introduction. So I was requested to do a presentation on prohibition and undesirability. This is about my key insights into prohibitions and undesirability from my experience as a former Home Affairs official. It'll basically outline what are the dominant types of Section 29, which is prohibitions, Section 30, undesirable cases, what evidence carries weight and what doesn't. I'm glad that a number of distinguished delegates have indicated that they are practical people. I've tried to keep this presentation practical, operational, basically it's a day-to-day insight into what you would experience representing a client to the department in these two categories. Challenges in this area of work, I'll outline challenges. I want to also be frank and fair to both sides of what I think is the same coin. A practitioner representing clients and a department that is servicing clients. Also look at some case law that's arisen in this area of work, in particular Section 29, which gives some good guidance in presenting Section 29 cases. So it's my insights, it's my perspective, it's not the view of the department or Fipsa. I am trying to talk from what would I want to see in my days dealing with these cases as a decision maker. Also, I don't have all the answers to questions, in particular time frames. I know time frames, yeah, it's a challenge. Responses from the department and of course shocking decisions. I'm now a civilian, I've joined the queue for services as well. So I queue like everybody else. Jumping off queue was not a favor extended to me on retirement. So yeah, I'm one of you. So just a brief background. I am a retired Chief Director Inspectorate. I was there for 17 years, from 2007 till 31st October last year. I did a few stints as a Acting Deputy Director General Immigration Services in 2020, which was a tough time during the COVID pandemic when people couldn't come through borders and they needed my permission to be able to enter, so the phone never stopped ringing. And so you can imagine someone in the US trying to board an aircraft, but they don't have a letter allowing them entry. And then of course, 2023 to 2024, which was really the height of the permitting backlog. I think on my tombstone, I hope it will say the permitting backlog clearance started with this man. So the inspectorate is responsible for immigration enforcement. So I joined the department to do immigration enforcement, which dealt with investigations, analysis, deportations, joint operations, management of deportation, detention facility, that's Lindela, that fell under me, and then prohibition upliftments and undesirable waivers, amongst many other things. The acting Deputy Director General, the role is overseeing the entire immigration regime in South Africa. So you're basically the national head. You deal with visas, ports. Nowadays, in terms of policy and Section 29 and 30, because the Border Management Agency was officially operationalized in 2023, in October. Also asylum seeker management, and of course the inspectorate. So I was also responsible for intergovernmental relations, which is basically that deals with the international engagements the department has with foreign countries, so negotiating visa waivers, returns agreements, so agreements in terms of deportations, streamlining of processes for particular countries and treaty visas, and then dealing with, in terms of intergovernment relations, dealing with Parliament and other departmental clusters. So prior to that, I worked in the UK. I was based in the UK for many years, having gone there as a child of a political exile. And I worked in the Home Office. My last job there was presenting immigration cases to court. They have an immigration appeal tribunal, so appeals don't go back to the same place where a decision was taken. It actually goes to what's called the Immigration Appeal Tribunal, where you appear before a judge, the departmental official, and a representative. So that was prior to coming to Home Affairs in South Africa. So Section 29, I don't think I need to read every part of Section 29. I take it everyone's familiar. Essentially, Section 29 is where you are declared a prohibited person, and there's a number of categories, from having a communicable disease, somebody that has an outstanding arrest warrant, to being previously deported, and then of course I think the common one. I'm quite sure most of you deal with Section 29(1)(f), which is anyone found in possession of a fraudulent visa, passport, permanent residence permit, or identification document. I think that's a bulk of the prohibition cases that the department receives. If you become a prohibited person, the avenue to have the prohibition removed is to apply to the DG for a good cause, or you indicate good cause, which is effectively is good valid reasons why you should no longer be declared a prohibited person. Section 29, they say it basically arises by operation of the law. You fall into the category. So if someone doesn't actually say, here is a decision that says you are prohibited, basically you fall into that category. You are detected with a fraudulent passport, there you are, you're already prohibited. And prosecution can follow, you can be taken through some form, through enforcement, but you can ask for it to be waived for reasons that we'll come to. Section 29, good cause. Well, the delegation in terms of Section 3 of the Act is where the minister under Section 3.1 or the DG can delegate their functions to another official. In terms of prohibition, it is with the Chief Director Inspectorate. So I had this delegation throughout most of my time in the department, and then there was a brief period in the last 2 or 3 years where it was delegated to the DG, and then it was delegated back to the Chief Director Inspectorate. 29(1)(f), I think 95% of the prohibitions are in the area of 29(f), with the fraudulent documents, passports, and the like. In terms of grounds of appeal, 95%, I would say, of that is usually a person saying they went to an agent. Their fellow countryman or woman told them to go to this particular person, they can get them a visa. Others, agents that are outside DHA or VFS offices. So I came to Home Affairs, there was a guy who approached me, said to pay 5,000, and next minute he came out with an ID or whatever. And it's usually paid in cash and it's not traceable. Sometimes, well, we met at a Wimpy, handed cash, came back 2 weeks later, there's a visa on my passport. And then a lot of South African passports in fake names. So you have somebody who gets a South African passport with not their real name. They marry a South African. They register the children with birth certificates in that fake name and eventually decide to come clean. Very difficult cases, but there are many of those types of cases. So the other one that's maybe second to the 29(1)F is the rehabilitation. So somebody who's previously deported, not rehabilitated, it's not as challenging. Normally the person's deported, been out of the country for 4 years, can show that, for 4 years they're rehabilitated, there's been no other fraud linked to them, all sorts of things, which show that it was just the fact that they were illegal and they were deported. But if there is fraud linked to it, it's very difficult to get that rehabilitation approved. So in terms of good cause, what is so important in the client's representation that should lead to the person's name being cleared? I think if the agent is well known, if you can, there's cases where someone says, well, this is the person I used, and the modus is quite well known, that can add weight to an approval. Proof of transactions is usually the strongest one. Here's EFT evidence, SMS communication. So there are individuals who would come and say, well, look, here's a WhatsApp. And on the WhatsApp, they've sent a WhatsApp to the agent to say, well, thanks, you screwed me for 70,000. I've been arrested or whatever. Usually that is supporting evidence that would be considered. Key thing is, what can you link that client to an agent? Then family life is a big consideration. So someone genuinely married to South African or PR holder, and then essentially the question is, can the representation present clear evidence that the client was a victim of a transgression? That is essentially what you want to be able to show and persuade the department. Generally that would, the time I was had the delegation, these would be the factors that I would look for and then say, okay, fine, there's an approval. Key challenges, mitigation, the team is small. Anytime that prohibition section could be possibly two people that are there permanently, and then maybe a rotation of staff from other sections. Nationally, the inspectorate is a very small team, 850 or less. We don't reach the figures of a city like London. In fact, in 2009, when we engaged with the UK, there was 3,000 inspectorate officials in London. We were not even 700 at the time. So it's a small team that has to, the inspectorate generally is a small team, but the prohibition section is very small, and they're basically trying to consider all of the prohibition cases that are forwarded to the department. The other challenge is if the prohibition is not presented with evidence that is verifiable, then the expectation generally is that you would hope the department would call the client for an interview, open an investigation, and confirm the story, which will not happen as they don't have a starting place. It's a very difficult thing. If there was the capacity, presumably one could do the investigation and support cases that are submitted by yourselves. In terms of presentation from representatives, I would say, if you can, do a thorough investigation. Build in the circumstantial evidence that can carry weight. If there's something that can show that even though there is no agent traceable, but on a balance of probabilities, there is evidence that can build the story. So on that particular day that the client indicates, well, I did get a Gautrain ticket that took me to such a place, or I did take a flight to a particular place where this person is based. There's other things, other people that were in a similar situation. It is essentially building a case, but if there's no agent traceable, it's generally a difficult one. If there is no agent, and nothing to support the story, but there's family life. Well, in terms of court cases, this should be considered as good cause. But for public servants, overlooking fraud or overlooking any type of fraudulent behavior generally would not be cleared without good reason. In my time, we generally would attempt to open a criminal case. We'd say, fine, there is family life, but let's open a case, at least get the case withdrawn or before, and then we'd say, well, fine, there's nothing in terms of a prosecution, nothing's going to happen, but there's family life. Let's rather proceed, because what the official has a fear of is that there's a favor that's they've overlooked the fraud, they've not addressed it, they're overlooking it, and there's a fear that that will come back to say, well, what did you do in terms of that? You bypassed it, even though you acknowledge there's family life. So the tendency will be to try and deal with find a way of dealing with issues where there's no agent. In terms of mitigation, if these cases could be taken through a mediation process, such as the Immigration Advisory Board before rejection. So if there's cases where there's agents not traceable, but there's family life, there's other aspects of good cause, is there a process of mediation that could happen from yourselves with the department? I believe that in terms of how Deng, the judge president, has encouraged that there be, before you take court action, let's have mediation. This is something that would probably ease the burden on officials who rightly believe the person should be punished. The challenge is, of course, if a criminal conviction arises, it presents a barrier to the visa, and then it just goes on, because the person is not going to leave the spouse and the children that are PR holders or South Africans. So these are processes that need to be considered. The other mitigating issue is to allow the internal process to be exhausted, then you proceed to court, which again extends the time frame. In terms of the recent judgment in the case of Indaba, a High Court case, it said that after a 29-2 is rejected, the avenue is straight to the High Court. I'm not sure if that is 100% correct. It's something, because I always feel that there's still a section 8, which says any adverse decision can go to, can be considered by the DG. Then you go to your section 8.6. So in terms of Fipsa, I think as an entity, really engagements with the department on this matter, so that there is a settled procedure on what constitutes good cause in terms of prohibition cases. The case law, I think a very good case is the case of Najemba, which basically said that it's incumbent for the DG and the minister to determine whether the applicant was complicit in the acquisition of a fraudulent work visa. In this case, Najemba had a fraudulent work visa, and what the judge was saying is that, look into whether the person was actually complicit. In Najemba's case, they actually gave evidence that they weren't. They actually tried to, deal with the agent, provide evidence of the agent, and, but they were still rejected in terms of, by both the DG and the minister. The DG and minister are also meant to consider other, factors other than just the fraud that had arisen in terms of good cause. So you don't just say, well, you did a fraudulent thing, that's it, close your case. What are the other good cause factors? And as we've indicated, family life is important. Case of AK, there were nowhere the judge said that nowhere in the reasons provided by the DG is there any indication that the DG or his officials pursued or attempted to investigate the first applicant's explanation that somebody called Aksu had perpetrated the fraud, and that the officials of the department may have been involved. So the person is saying, well, it was a guy called Aksu, he knows officials, he did whatever. But the rejection didn't go to that, to say, fine, we have done whatever, and we have done the following. So it's very important to point out that there still is, you actually are the state. What are you doing to look into the allegation that the client has presented to you? The court further stated that it's apparent the DG only focused on the alleged transgression and ignored all the other reasons. So basically just said, fraudulent visa, done, closed case. But you should also address the other issues the person has raised. So they basically are indicating that the specific section says good cause. And you need to define what good cause is, and you define what isn't good cause. And if you don't point that out and say, well, you had a fraudulent visa, done, then that's not the correct exercise. Then moving to section 30, undesirable persons. In terms of section 30, I think the key one, the one we deal with, is the overstay with appeals. I won't read through this. If colleagues are not sure, we can come back to it. But for sake of time, let me jump to what is a section 32 waiver, and what would remove an overstay, a block from a client. The delegation for a waiver, a section 32 waiver, in terms of the act, the minister can waive the undesirability, but the delegation for determining this is with the Deputy Director General. It used to be the Chief Director Inspectorate, then we had, in 2019, Minister decided no, he will adjudicate these, and then it was moved back to a DDG just before I left the department. 95% of the undesirable cases, commonly referred to as overstay appeals, are essentially the people who overstay. You do get very few where somebody did a visa application, presented a fraudulent medical certificate, fraudulent SAQA. You get a few of those, but not as many as the overstays. The common issues, I think medical, big one. People overstaying for medical reasons. Others who come on a 90-day, and then day 89 or day 80 go over the border, turn around, come back, and assume they've got another 90 days. And then when they leave, 90 days later, they're told, no, you've overstayed by however many days. You're coming from the US or UK, you've got a 90-day. If you go over to Botswana on day 80, you've only got 9 or so days left. So something that may not apply to our neighboring countries. Our neighboring countries, they can have an issue of coming back and forth, but certain non-visa waived countries don't have that. So assuming I had 90 days, I left, came back, thought I'd get another 90, and then when I left, I was told, no, your 90 days expired when you first came through the port of entry. Flight cancellation, very common one. So flight cancelled, the airline drives you to a hotel, you fly the next morning. It's 1 day overstay. Car breakdown on the way to border, very common one. Became a citizen with a foreign passport. They can't renew the South African passport, or it's not going to come in time. They leave with a foreign one. Told, oh, you've overstayed over 1,000 days, and that one happens. And then common one, again, awaiting visa outcomes, although there are concessions on awaiting visa outcomes, but sometimes people travel without the VFS receipt, they get a overstay. So, as I said, fake SAQA, professional certificate, medical reports, they arise from time to time, but the bulk is overstay cases. Waivers, what is important that should clear the waiver? The overstay. Verifiable evidence, medical reports that can be verified, the flight delays or arrival at ports of entry just after midnight. What is the evidence that you give? Sometimes this person says, yeah, I went to Quick Fit, I had to wait till the morning. Look, I went to Quick Fit near Kopfontein border, flight minors. It's a strange one, this one, minors. If I was king for a day, I would have said, well, what do they know? They're in the, they're under the care of a parent, so, giving them an overstay or ban, it's thing. We've had, a baby born, 3 months, gets the Italian passport, leaves, and then gets an overstay ban. Doesn't make sense. Then, of course, family life, married to a South African children, the mum goes back home for a funeral, you get a ban. I mean, that should be an upliftment, because that in terms of case law, constitutionally, right to family life is sacred. And then in issues where it's not your fault because you're awaiting a visa outcome, what will always be a definite rejection will be, did not check the passport. So I left, I overstayed, I didn't check the passport, assumed I had 90 days. Generally that one, I don't know of cases where that was accepted as a reason. Maybe I may be wrong, but not in my experience. And then key challenges. The overstay section is very small. It's a small team, possibly 5 to 10 people at any given time. I think when you consider some of the challenges, and now talking with the departmental head, 72 ports of entry, daily arrival at OR Tambo exceeding possibly 20,000 per day, Bite Bridge 16, and then you have some of the medium ports, like Maseru Bridge, your Kopfontein, Skilpad Hekwi, which then go down to the 3,000, 2,000, and you have smaller ports with a few hundred. If out of those daily movements, 1% are overstayers, per year, that is a huge amount. If you were to just do the figures of how many people come into the country daily, and then if just 1%, or even 0.5% were to overstay daily, that's a huge amount of work. So some of the engagements that I think would be helpful in discussions with the department and the BMA would be clearing of automatic categories that can be cleared directly. The digitization process, really that should be able to clear the lapse cases automatically. So people who've served the 1 year or the 5-year ban, having to now send representation into the department as an appeal to clear the lapse, it just adds lots of volumes. A lot of people actually serve the 1 year or 5-year ban and find that a guy will travel from the US, as soon as he's trying to board in Amsterdam or London, not the block. And then they're told now you must now send into the same overstay team to get a clearance, to clear your name, and that basically just adding to the number of overstay cases that need to be considered. So clearing of the lapses automatically, something we attempted for a long time. I hope with the minister's passion in terms of digitization, this will be one of the early processes that's introduced. And then overstays that are not more than a set number of days. There's leeway in terms of when you renew your licenses, you can do it within 14 days of expiry. Could that be a consideration as well? So many days overstay can be an automatic uplift, or with cooperation with BMA, not be a block on the person's name. And then minors, again, if you're at a certain age, what process can be brought in here to look at the issue of minors? Although there's a caveat here, because if the parent has maliciously overstayed, obviously it's a whole family entity. But if it's a minor who's been attending boarding school or has been, and for some reason they left a little later because of issues, exams were held later because of load shedding or whatever, something like that. Those are things that could be considered. But I think for Fipsa, streamlining of processes will be a key engagement to consider. And then in terms of implications for foreign nationals, I think overstay has brought in, on the one side, it's brought in effective immigration control. There was a lot of malicious overstaying prior to 2014. People would overstay and were told, oh, there's a fine you owe, but you can come back. This brought in effective control. Basically, government had a regime and people realized, look at the visas. Because what you found, in the old days, person will overstay here without no thought about it. If I'm fined in euros, whatever, it doesn't matter. But I would not dare do the same thing in Germany or the USA or wherever. But in South Africa, fine, I'll do that. And that's something one must always remember. When people raise issues, can you balance it with what you would do when you go to another country? Because we've had times where people would say, fine, I realize my South African passport's expired. I need it today because I'm going to fly. And you're like, okay, but you have dual nationality. Why do you not forget to renew the US passport? The South African one doesn't matter. So we've got to always remember to encourage balance. So our role, we know that we service clients as small business owners, whatever, but there is a responsibility to also encourage compliance, and that there is, they should be respect for the legal processes as well. So, what I'm saying here is that overstay brought in effective immigration control. However, with no streamlining or improvement to the system, the following problems will occur. Clients will be unable to return for urgent medical treatment. So we have people on dialysis, getting cancer treatment, other life-saving treatment, which is very serious. If you do not deal with their medical overstay appeals quickly, it's life-threatening. Lapses which are not cleared, it causes undue frustration. You arrive at check-in and you're refused boarding. Family life, cases children and spouses are South African or PR holders, it's enforced deportation of a South African or PR holder. So cases where the foreign national married to a South African has just given birth, wants to go back to the home country, passport was stolen, they get the new passport, they travel, by the time they receive it, it's 3 months later, they have to take the child out of the country, child is traveling with a South African passport. You are basically enforcing, it's unconstitutional, because what you're basically doing is it becomes an enforced overstay of the South African child, which is unconstitutional. So not being able to deal with some of those cases like that is a problem. And then delays in being able to apply for new visas, students overstaying for results, for resits or exams. It happens. And they overstay for those reasons has serious implications, especially if they've registered to come back, if they're a top student, registered to come back for doctorates or whatever, or a company has identified them as the next top neurosurgeon or person who's going to, develop the South Africa's form of a Tesla. That has implications. So there are many implications, but as I said at the beginning of this slide, you do need to strike the balance between effective immigration control and efficient servicing of clients. That is basically the strategic objective, I think, for both government and practitioners. Essentially, I take the view you're two sides of the same coin. You're not standing at loggerheads. You're basically trying to get a service done, trying to do it efficiently and I mean legal practitioner, meaning, officers of the court, and you obviously want compliance with the legislation effectively. So I would, if I'm allowed, say that I would want a key question that would need to be answered would be, what strategy do you adopt for some of the issues you face as immigration practitioners as a way forward regular engagements with the department or IAB on some of the key concerns in this area. I don't know, maybe you've attempted to do this for years and it's been it's a closed door, but I think, you know, doors eventually open. But I do think if at the level of the executive here and either the Immigration Advisory Board or senior immigration management or management of home affairs, because I know you deal with civic issues as well. I think that's an important one. Also, what support could you provide the department in considering these cases? From send to acknowledgement of receipt to updates, there's no need for there to be a closed door. So how do you receive, because the engagement can end up being one way, say, well, there's absolutely no receipt of, no acknowledgement, nothing, we don't know what's going on, we're in darkness in terms of servicing clients that are expecting a service from us. So how do we get there? How do we get rid of this particular closed door? Another issue is firm time frames for decisions. If it's not possible, what communication processes can be in place? Because now, if I was to ask any of you, what is the time frame for a TRA, temporary residence appeal or permanent residence appeal? You probably all give different answers, but you probably say, well, we've not received anything for 5 years, 3 years, 2. Oh, you said 5. So the time frames, getting that acknowledgement. In terms of prohibitions, the time frame, the actual charter time frame was 90 days. For prohibitions, good causes. 60% within 90 days, and then it was, for undesirables, it was so much percent within 28 days. That was the kind of objective, to try and do those, because if it's an investigation and the client wants something, and you know that, okay, come forward, let's interview. So there are time frames, as well as your permanent residents, all of those, there's time frames. But if those can't be stuck to, what is the communication that you receive in terms of time frames? And then, of course, the key objective should always be a fair decision. How can Fipsa assist and ensure that is what the department does when considering these cases? So a fair decision. Is it possible, if the notarial certificate is not stamped, rather than reject, what stops you contacting the client or saying, Fipsa, this is what's happened, this is a situation with these people, can you help us to, do what, I don't know what, but there are cases where there are rejections for things like, this was not stamped. There was no date stamp on the medical thing submitted. But even though there was a doctor's letter, or the doctor does not exist. But then a different team sends a local inspectorate to go and verify, and they say that doctor does exist. Or you contact or the doctor says, but I have an arrangement with the department, they never checked with me. There are times that has happened. So how do you cut through some of that? And then there needs to be a joint interest. I think there needs to be an interest on the side of yourselves as legal practitioners in terms of protecting the borders of the country as well as servicing clients. So that balance, which is the interest of the department, should be the interest here as well. We protect borders, but we service the clients who require service to get to fair decisions. We see an injustice, we feel we can assist. That is basically that is where we should be going. And I'm talking sort of at the strategic level. I mean, because I know at the operational level, where it's, go to the local office, that person didn't want to receive a good cause, or that person was rude, that we know. And but I'm saying, if you at this level can have a type of relationship that can allow for these processes to be engaged in, then that was what I would recommend. If it's, I know we chase outcomes, but also in the engagements, understand capacity issues, So that we're not talking at cross purposes. So we could easily say, this department, it's all over the place, they don't do this, don't do this. But say, but how can we get to that point where you could ask us as a practitioner to say, we are dealing with a particular case, do you know of such a person that assisted this person? Do you, what have you come across in terms of somebody who's alleged to always be outside VFS helping people? How do you deal with those? The ones who would give you a bad name. So generally, for every official that is dealing with immigration control, be it adjudicating visas, investigations, or whatever process involved, you are probably dealing with 30 urgent cases per day. And on top of that, there is more that is added that is urgent. What role can we play as practitioners here? My view is an Indaba of this nature is an excellent initiative. Other industry have these engagements, mining Indaba, the security, Pasira security industry, small businesses. This should be a standing arrangement, but the key role players, of course, that were here in person today, I think that should be well applauded, and also that, Mr. Mbele coming through. I think this is the type of engagement that is critical. I think you as industry in this area do need to have a seat at the table with the department. And then international benchmarking. I think the UK has the Immigration Law Practitioners Association, very influential in terms of dealing with the UK Home Office. They are listened to, and they do have the departments coming to them for help and advice as well. So sorry I took long, but in conclusion, I just want to say that I'd like you to note the presentation, and the warm thanks are extended to you as delegates and the organizers for the invitation and opportunity. Thank you very much.
Thank you, Mr. Matthews. Ladies and gentlemen, we're about to come to an end of our official program, but the recommendations from Mr. Matthews in navigating the terrain and complexity of the issues that are faced by immigration practitioners at the Department of Home Affairs, I think needs to be taken to heart. I think we need a workshop actually with Mr. Matthews. Mr. Matthews, you just need to extend your availability. There's a need for an additional workshop. Can you just give him a hand of applause, ladies and gentlemen? The apex of our conference for the day. Thank you. We have another important speaker, ladies and gentlemen. I know we are running behind time. Our apologies. From there, then we're going to be able to have the delegation as well, the leadership of Fipsa, just to be able to sort of end our program for the day with regards to the positioning of Fipsa as we proceed. We have Mr. Temba Mugwena from SAQA, who's going to be gracing us on stage shortly. Now, the South African Qualifications Authority plays a key role in recognizing professional bodies such as Fipsa by ensuring they meet defined standards such as legal status, ethical governance, and professional development. Recognition by SAQA lends credibility to organizations such as Fipsa, promotes public trust, aligns their designations with the National Qualification Framework, and supports the professionalization of the immigration sector. This helps to ensure that immigration practitioners operate ethically, maintain consistent standards, and contribute to effective regulated migration services in line with national policies. Please, ladies and gentlemen, let us just welcome Mr. Mugwena to take us through this process. Mugwena, you can proceed. We hear you very well.
Okay, no, that's perfect.
Thank
you very much, Program Director. I think you have summed it up nicely in terms of the role that SAPA really plays in the, national schemes, if one can actually put it that way. The shadows have lengthened, colleagues. Not gonna be long. I hope you can still hear me because I'm getting this message that my signal it's a poor. So good day everyone. I'm Temba Mukwena. I am a specialist for professional bodies at the South African Qualifications Authority. I must say that SAPA really feel honored to be part of this important endeavor of Fipsa. I think it is also important that SAPA be part of this occasion because SAPA has a statutory responsibility to recognize professional bodies. We really see this as a practical demonstration of the fact that a professional body like Fipsa, which we have recognized, is indeed, working, and we are very much grateful for that. To get straight to my presentation for today, if we can move. Colleagues, can we go to the next slide if you can hear me?
My apologies, it is attended to.
Oh, perfect. Thank you very much. Colleagues, I just want to quickly go through this. I'm not going to take more than 10 minutes with my presentation. The SAPA Act of 1995 is actually the first legislation, education-related legislation in the democratic state since 1994. So the SAPA Act of 1995 established the South African Qualifications Authority, which began its operations in 1997. Now, in 1998, we will all recall there was this 8-level NQF, which was established through what we used to call the National Standard Bodies and the Education and Training Quality Assurance Regulations. Now, between 2002 and 2008, the SAPA Act of 1995 underwent a review process. Now, the review process resulted in the replacement of the SAPA Act of 1995 by the NQF Act of 2008. Now, the NQF Act of 2008 introduced a 10-level framework. In the past, as you will recall, the standard setting and quality assurance role of the NSB and ETQAs were actually replaced by the 3 quality councils, that is the CHE, the QCTO, and Umalusi. Okay, the NQF Act, Chapter 6 of the NQF Act provides for SAPA to recognize professional bodies and register the professional designations of the NQF. Now, Section 13I, Roman figure 1 and Roman figure 2 of the Act requires SAPA to develop and implement the policy and criteria for recognizing a professional body and registering a professional designation for the purposes of the NQF Act. In 2012, the policy and criteria for professional bodies was published, and the first group of professional bodies were recognized, and their professional designations were registered on the NQF. To date, 101 professional bodies are recognized by SAPA. 16 of these professional bodies are statutory councils, 85 are non-statutory professional bodies. Okay, the reason why SAPA is recognizing the professional bodies, firstly, we want to advance the objectives of the NQF, also to promote public understanding of and trust in professions through the establishment of a nationally regulated framework for the recognition of professional bodies and the registration of professional designations. Also to encourage social responsibility and accountability within the professions relating to professional services, communities, and individuals. To encourage the setting of professional standards by professional bodies, promote pride in association for all professions, including traditional trades and occupations, ensure the sustainability of professional bodies, which include financial and human resource capacity. Also to promote the protection of the public from malpractice and unethical behavior related to non-fulfillment of the professional duties and responsibilities of professional bodies and their members, to encourage international leading practice and the raising of esteem for all professions in South Africa, to facilitate access to an analysis of data related to professions, including traditional trades and occupation for the purposes and use as prescribed by the NQF Act. Encourage the provision of alternative access routes into professional designations through the recognition of prior learning, support the development of a national career advice system, ensure the development and implementation of the continuing professional development. Okay. Now, the recognition of Fipsa, the relationship between SACPA and Fipsa actually started in July 2015, when SACPA recognized Fipsa as a professional body in the sector. So, in other words, Fipsa is the only professional body that operates in this particular space. So, since 2015, SACPA conducted 2 midterm monitoring site visits and 2 re-recognition site visits of the Fipsa. So the midterm monitoring site visits that we conduct is to come and sort of verify, evidence that Fipsa actually complies with the policy and criteria for recognizing professional bodies. So the results of these 4 site visits was that Fipsa complies with the policy and criteria for professional bodies. Now, SACPA recognizes a professional body for a 5-year period, and thereafter it recognizes the same professional body for another 5-year period if it complies with the policy and criteria for professional bodies. And here also suffice for me to say that maybe one thing that we would also need to look at is that there is a sort of a correlation between the world of work and the world of education and training. That's one of the reasons why we recognize this as SACPA, which is the custodian of the NQF, to say that what really informs the professionals or the professional bodies to accommodate people into different professions is simply because they have acquired particular qualifications. And those qualifications must actually be SACPA registered qualifications. And then we know we have trust in the professional bodies because if the people who are designated are the people who have some qualifications that are SACPA recognized, there is a lot of credibility that is there, and also assist in protecting the interests of the public. And then we all know that the SACPA registered qualifications are of quality because they are quality assured, and also to say they are internationally comparable. So it increases the credibility of a professional body. Why I'm raising this point, colleagues, I think it's important to, because now I think Fipsa will be coming for recognition. You will be recognized until 2030, if I'm not mistaken. And I think now it's an opportune time for Fipsa to sit down and do a reflection in terms of its role in the quality assurance space. Why am I talking the quality assurance space? Because if you look at the professional designations that we have, I think we've got about 4 professional designations that are registered with SACPA. The question is, are these professional designations really underpinned by the qualifications that are SACPA registered? And are these the qualifications that can really prepare someone to function effectively in a society? In other words, I'm talking here about the level of the qualification, where the qualification is pitched. I just want to give you an example. If for an example, you say an immigration practice general auxiliary is actually underpinned, this designation is underpinned by grade 10 or level 2 qualification. Can we really call that person a professional? So those are some of the things that you really need to sit and reflect on as you proceed with your work of professionalizing the immigration industry, to ensure that it's highly professional, is in the position that it can play an influential role in the quality assurance system of the country. Thank you. Can we move? Okay. SAPA, what happens now is that when we look in I'm happy the officials from the Home Affairs are here today. They can, because these things, they keep on changing all the time. There are lots of amendments. Some of them, you're not even aware of them taking place. But in terms of the 2023, in October 2023, the Department of Home Affairs practice published the critical skills list in terms of Section 19 and Regulations 18 up to 5 of the Immigration Act of 2002. I put as amended there because for obvious reasons. Now, the list is a consolidation of occupations in high demand as compiled by the Department of Higher Education. Now, in terms of Regulation 18 of the Immigration Act, an applicant for a critical skills work visa shall be accompanied by a proof that the applicant falls within the critical skills category in the form of a confirmation in writing from a professional body, council or board recognized by SAPA in terms of Section 13(1) Roman figure 2 of the National Qualification Framework Act, or any relevant government department confirming the skills or qualifications of the applicant and appropriate post-qualification experience. And also, if required by law, proof of application for a certificate of registration with the professional body, council or board, or recognized by SAPA in terms of Section 13(1) Roman figure 1 of the National Qualifications Framework, and a proof of evaluation of the foreign qualifications by SAPA and translated by a sworn translator into one of the official languages of the Republic. Colleagues, I think having also said that, I want to say that I think we're having very great discussions here, very much insightful. I'm also learning a lot because we just see Fipsa during the times when we do the midterms and the recognitions. Now, sitting here, one is exposed to different stakeholders that really play a very important role in the work that you do. So it's sort of a learning curve. Maybe one other thing that one can add, I don't have what we call the so-called recommendations, but having an experience in the work of the professional bodies, I would say one of the things that we also need to look at is the issue of the good corporate governance practices. I think we've got a King 5, under our DSA and all that. It really has got principles in terms of what good corporate governance practices is ought to look like, whereby the people who are ought to do the day-to-day running of a professional body are not supposed to be the people who are actually board members who play the oversight role. So you cannot be the referee and the player at the same time. So those are some of the things that you perhaps need to look at as a professional body. So this one, it is just to share with you that SAPA was actually celebrating 30 years since the NKF Act of 1995. We had a very good birthday celebrations a week before last in Johannesburg. So yeah, that's it, colleagues. Thank you very much for your attention. If there are any questions, I'm very much ready to take them.
Thank you, Mr. Ndona. For the interest of time, ladies and gentlemen, I'm just going to take two or three questions, please, and then we can be able to delegates that are going to be coming through the leadership of Fipsa. Is there any one or two questions, perhaps maybe for the interest of time, that we can be able to ask, opposed to Mr. Mkwena? Okay, so if there's no questions, Mr. Mkwena, thank you very much. Thank you for your time. We will share the presentation and your details through the Fipsa leadership. If there's any other inquiries, thank you very much for joining us. We are grateful. Thank you. Now, as we approach the end of our Indaba, it is important that we highlight Fipsa's pragmatic role in South Africa's immigration practitioner ecosystem as a professional body that promotes standards, offers members benefits, and gives practitioners a unified voice. For clients of immigration services, using a provider who's a member of Fipsa is validation that you are using an immigration expert who's an ethical, competent service provider in South Africa's immigration landscape. To unpack this further, ladies and gentlemen, please welcome Mr. Rod Maxwell, Chapter Chairperson, Western Cape for Fipsa, and also
Recording
Ms.
in
Nadia
progress.
Hines, the Deputy Vice Chairperson, Legal, to unpack this in detail. Can you welcome them on stage, please, leadership? Thank you.
Oh yeah. Good afternoon, ladies and gentlemen. My name is Nadia Hines and I'm the Deputy Vice Chair Legal of Fipsa. So a very warm welcome to everyone joining us today. It's been a long day and we'll keep this short and brief. We have our first immigration Indaba today, hopefully one of many to come. And this will be the platform where stakeholders and Fipsa, the public and professionals can all join together to contribute to the South African immigration sector and landscape. Our goals for today can be summarized in 4 areas. Pretty much sharing knowledge, where this Indaba was the opportunity to gain clarity on immigration updates, current trends and future policies. As the Honourable Minister of Home Affairs, Dr. Schreiber, already touched on in his recorded address. Furthermore, it was to link immigration and economic sectors. We looked at how immigration supports South Africa's economic growth through business opportunities, corporate visas, business visas and investment opportunities, as well as migration's role in the employment and labour sector, ensuring South Africa remains an attractive destination to visit, work and invest in. Furthermore, it's promoting professionalism in the industry. We'll also be highlighting the important role of registered Fipsa immigration practitioners. Too often, unregistered individuals offer immigration advice and are mistaken for Fipsa registered practitioners. At Fipsa, we ensure that our members uphold our code of conduct, ethical standards and professionalism. We also provide a formal platform for the public to lodge a complaint if they feel a member has breached their professional duties. These matters are then referred to our disciplinary committee for further handling. And finally, networking and collaboration. Today is about building connections between practitioners, government officials, legal experts, and international representatives. We encourage everyone to use this opportunity to engage, network, and form partnerships that will strengthen our collective efforts of shaping South Africa's immigration future. Fipsa's role at the Indaba goes beyond just hosting the event. We aim to facilitate knowledge sharing, promote and collaboration, and strengthen partnerships across the immigration sector, and most importantly, also take note of the advice given by our dignitaries and colleagues alike. Today we've explored the challenges facing the industry, proposed solutions, and created constructive dialogue on key issues shaping South Africa's immigration landscape. You will shortly hear from Mr. Rod Maxwell, who will speak on who is Fipsa, why it was established, as well as Fipsa's main objectives and the range of services that we provide.
Thank you. You know, as I stand here, it's a very proud moment because SAP was recognized, Fipsa now will be for 10 years until 2030. And one of the problems that long ago, and Dr. Naledi Pandor a long time ago said to us, organize yourself as a self-regulatory body. And one of the challenges of a self-regulatory body is nobody's pushing you. You have to do the initiatives, you have to set the standards, you have to have a benchmark, you have to have and push yourselves as an organization. That was the one side of it. The second side of it is with, and Gershwin alluded, the chair early on when he asked Mr. Mbele, what is Fipsa's standing with the Department of Home Affairs? Because that has been our journey for the last since 2014, and I'll go into that in a few minutes, but that has been our journey to get that recognition, to say to Home Affairs, we're a stakeholder with you. We're not your enemy, we're a stakeholder. Talk to us. We want the same thing, and we live in the same country. But that's why the whole issue of education, putting ourselves out there, and even for the minister's address this morning, was probably a major highlight, even to get to that stage for us. So we're incredibly proud of where we stand today. I'll do the next slide. So when you look at, and Nadia mentioned Fipsa's objectives, professional interests of our members, unify and speak with one voice. Because right out there, and I remember we had a meeting with Mr. One of the former DGs, and we asked him after Section 46, we said, why don't you encourage everybody to join Fipsa? And his response to us was, everybody must eat. So you had a situation where you are trying to regulate your own industry, but there's very little support from the department. And so they talk about agents, and they talk, and we got very upset with that. We're not agents. But to be able to communicate that to Home Affairs, to the public at large, and we know that in many cases when the department would refer to us, and then in the press we would be agents, and it would upset us to break, and that's why we try to educate them, meet with them, and recognize that the industry that we are in, we're not agents, and we're not street agents. There's a big difference, and that's why SACWA's recognition says we subscribe to a whole range of values. That means if any of our members of these transgressions, they've got to, they go through a disciplinary committee, a whole bunch of things has to happen. So it's incredibly proud. So we've got to jump through a whole lot of hoops. And the biggest one was to self-regulate yourself. Thanks, Nadia. So Fipsa members provide certification for new members. We try and educate the stakeholders out there. So we have meetings with, for example, Department of Labor, Home Affairs, many other Department of Trade and Industries, and it's just engaging with them and saying, let us, because we are the lens through whom a client would look and say, I want to come and invest in your country. And we are the ones that would be the ones that they would be talking to. And then we need to communicate the changing world that we live in to a government official. And often a business comes to somebody or an employer or whatever the case is. In many cases, the government official, for example, may never have run a business in their life. So they've done the qualifications and whatever, but they don't have the practical experience. And we want to communicate that to the departments, to Home Affairs, Department of Labor, etc., and say, the world is changing. Can we not show you a different world? And we all want the same thing, which is unemployment. We need people to be employed, and that's the whole issue. And that's what SAQA pushes, Fipsa pushes all the time. Next slide. So what we've done, and SAQA, in the earlier chat about the gentleman from SAQA, and he mentioned and he touched on something, which is how do you, the professional recognition. So we have a number of designations, and the first one is an immigration practitioner, second one is an immigration practitioner associate, an auxiliary, and a fellow. So generally speaking, the fellow is generally somebody, it's a lawyer, come on board, been recognized by the legal professional council. And then you got a second body, which is somebody wishing to apply and become a practitioner. So you must have had some experience in the industry, and then you write an exam, and then you get, obviously you get, and once you pass the exam, you get admitted as an immigration practitioner. Now then we came up with the same, but how do we bring people through the system, and how do you educate and bring, for example, you've got staff working or new people wanting to come into the industry. So Fipsa came along with an immigration practitioner and an associate. So now you would work in an immigration firm. You would have 2 years experience, so somebody would give you almost like a learner's license, that type of thing. And then the last one is our staff, for example, who would go to VFS, Home Affairs, or whatever, and we would then introduce them at the very, very early stages, and the badges that they would get, for example, they would say, but that's a Fipsa member over there, and they would then have pride, because I'm now belonging to a professional organization, and I'm not just an agent. So yeah, that's Fipsa. Okay, so again, the idea of Fipsa wants to educate members of the public. We want to work with the NGOs, governments, for example, there's all the stakeholders, and they all impact one another, or we all want the same thing, which is South Africa to grow, and we must work together. And that's why this Indaba is so important, bringing all these stakeholders together, and together we can talk to one another and begin to shape a new South Africa. And we want to build the public's trust into saying, hang on, there's a difference between an agent and an immigration practitioner. There's a big difference. And the fact that you all are here means there's an acknowledgement of that. And obviously, probably the biggest one is to prevent fraudulent practices. So, for example, that we keep that pressure on to say there's a difference between an immigration practitioner and a street agent as such. Okay? And for example, we just to give you an idea of how closely we work with the Department of Home Affairs, VFS. So for example, Mr. Mbele referred to the bride for hire at the various VFS offices. So we work behind the scenes with the counter-corruption unit of VFS, for example, and we identify them, these people. The team then goes in, and if you go into a VFS office nowadays, you don't see any of these brides for hire. We, in fact, a lot of the fraudulent agents are no longer there, and the dates are available faster than before. So that does work. And for example, with Home Affairs, for example, on the counter-corruption unit, Connie, we again, we work closely with her, and so when we become aware of a particular situation, we feed that information to Home Affairs because that's our responsibility too. That's right. You need to answer that.
Okay, so for anyone interested in joining Fipsa, you can visit our website to complete the online membership form. You have to upload your documentation and submit everything online. Once again, incomplete applications will not be considered, so please ensure that you upload all the relevant documentation before clicking that submit. On the application, once the application is assessed and a recommendation made to and considered by MANCO, successful applicants will be notified of their outcomes. For those applying for the Professional Immigration Practitioner or IPSA designation, acceptance is provisional until the applicant passes this examination with a minimum score of 65%. After completion of the membership application process, if you've passed the examination, then you'll be required to make the required payment for your membership fees. Thereafter, members will be welcomed to the Fipsa family and issued with a certificate stating your status as a good standing member of Fipsa. Here we've just got an example of our Fipsa membership certificates and in its current form. I do want to stipulate that going forward, in order for our documentation not to be fabricated and falsified, we are going to put a QR code on there that is scannable so that VFS, the Department of Home Affairs, can verify the authenticity of the membership certificate and that particular member's details. And then for further questions, you're more than welcome to contact our Fipsa offices, our website, our email address, contact number, or visiting our Brooklyn branch. Thank you very much.
As we end our program, I'm just going to take a few questions from the floor that will be posed to the Fipsa leadership, please.
Yes, it's Mr. Practical, but it's probably time that I reveal myself. I'm Dr. Andre Visser, and I'm a member also of a professional body called the South African Medical Association. It started in 1927 as the Medical Association of South Africa, and in and it started in splinter groups then going forward, and in 1997 we also had to do the SAQA thing and did the South African Medical Association. My area of speciality is not politics, it's pediatric surgery. Regardless of that, I want to congratulate Fipsa for this whole thing that they have done. A tremendous, massive job, although I had vested interest in this. The other thing, with a compliment, I want to give you guys a warning. Join Fipsa, that's the first warning. It needs to be regulated. You need to become part of Fipsa for you to have a regular standing and be regulated. The other warning is the following. As you could have seen, that government Department of Home Affairs was quite absent today. It happens at our conferences as well that Department of Health is absent. So the fact of the matter is that this really needs to be pushed as a narrative, and you must be very careful that the government does not only provide you with lip service. You have to, unfortunately Mr. Matthews is retired, so he's, we're probably preaching to the wrong people. The thing is that except for the fact that it's lip service, politics in South Africa is not combined with truth anymore. So that narrative needs to be pushed too, that when you actually engage with the government, that you come up out of there with the truth. And that's basically my message. Have a lovely evening.
Thank you. Any other comment from the floor before we close?
Thank you very much. I've been invited to the Fipsa, Actually, I'm a retired control immigration officer. I'm also an associate trainer. I've just qualified with my BA NLP, and I want to know, where do I start if I need to pursue this type of job at Fipsa? Kindly advise me, where would I start? Thank you so much.
Thank you. Any other follow-up question? Okay.
Okay, it's very simple. Step one, as Nadia pointed out, you're going to go to the website, you're going to get all the information, you're going to, and if you go to our website, we'll tell you exactly how you become a member, the hoops that you've got to jump through, and we're always looking for new members, so you're more than welcome. Thank you.
Thank you. Thank you. Thank you. Yes. Ladies and gentlemen, we have come to an end of our Fipsa 2025 Indaba. Before Mr. Maxwell closes our official program, our key takeaway from this Indaba as immigration practitioners and also the key stakeholders that are forming the entire immigration system. There's questions that, ladies and gentlemen, perhaps maybe even Mr. Maxwell is going to pose to you. One, how do you maintain the theme of collectively contributing towards an efficient immigration ecosystem in South Africa? How do you collectively advance immigration reform? How do you collectively move towards from rhetoric towards a realization of tangible, measurable outcomes, and hopefully that next year, once again, you'll be able to gather here and be able to have tangible outcomes on issues that have been raised on this Indaba. On behalf of myself, Sindiswa Changuion, I would like to thank you for the opportunity. Thank you for allowing me to spend time with you for the day. I am grateful to the Fipsa Menko. I am grateful to all the delegates. And I'm hoping that next year as well, you wouldn't mind me coming back here. Thank you very much, ladies and gentlemen. I am going to ask Mr. Maxwell to close our Indaba for the day. Thank you.
So from the Fipsa side, we know your time is valuable, and we know also that you could have been somewhere else today. So we don't take that time lightly, and we thank you for the time, and we thank you also. I mean, everybody has stayed, and we thank you and that indicates that this is a topic that's a burning topic, and it will help take the country forward, because what we are doing over here contributes to the jobs, to what everybody else is asking for. And the most important thing is that let this be the beginning of greater things, and shaping policy and being part of a think tank to just open up the space for immigration, for work, and there's room for all of us. And I thank everybody for coming on behalf of the Fipsa management team. I just want to say also to my colleagues on the Manco group, you can now tonight sleep. They worked many long hours, and our practical man there, he probably knows more than most other people how difficult it is to even engage, to get people to come and be here. So we value this, and the ones from the different government departments that have come here, we thank you, and we don't take that lightly. We want to thank you. Just on a separate note, Gershwin should have been here, but he's been taken to hospital. I know he would have wanted to have closed it here, but just remember him in your prayers and your thoughts. So we thank you very much, and I declare the Fipsa Indaba 2025 closed. Thank you.